and welcome to Reasonable Doubt. My name is Murray Newman. I'm the president of Harris County Criminal Lawyers Association, and I am your host tonight. We have a very exciting show. One of the lesser known parts of what makes it exciting is we have the long-awaited return to the studio from Justin Harris. Justin Harris, normally broadcasting from his garage, is with us live.
Yeah, there's not only like not exposed studs in here, but there's like curtains and air conditioning. This is great.
Times have changed, and actually we have digital. It's amazing. We're no longer rolling on the thing. We don't have a cameraman having to crank the film anymore. It's amazing. But what a great event for you to come out, because we're very honored to have my friend and candidate for Harris County District Attorney, Sean Teare, with us tonight.
Yeah, I'm excited to be here. You're right, it's changed. First time I was here was 2007, I think, and
Nice.
It's a little different.
It's a little different. I think I was the host back then too. I still had a full head of hair.
Well, I mean, I feel like that's revisionist history, but whatever.
Just for the record, Kim Ogg, our sitting district attorney who is running against Sean Teare for DA, was invited. She let us know that she would be unable to attend tonight, but an invitation was extended and declined. But we're glad to have you here, and I think that. Obviously, this is a very heated race. It's probably the biggest local race we've got going on in Harris County.
Certainly in my mind.
Well, yeah, I mean, it's like, whatever happens to me, I'm really worried about the JP race in Precinct 7.
But who isn't?
But, I think that it's been a very interesting race so far because, number one, it seems like in some ways it's gone by so quickly, and in other ways it seems like it's been going on forever. How does it feel to you?
Much more the latter. It feels like this has been going on for quite a while. I'm excited for this discussion because, when I have to explain a lot of the points and the reasons I'm running to the vast majority of the groups I'm talking to, there's got to be a lot more explanation than there does here because we're all in that building every day and we see it.
Sure. Well, we brought Justin in so he could explain it to me because there are still some points that I missed. But, I think it's fair to say that this is a race that there's been a lot of negative attention certainly brought to Kim Ogg. And so much so that it's kind of easy to get lost in the negativity towards her, that you actually are a pretty good candidate on your own.
I like to think so.
I'm a fan, but I've known you for a long time. So tell us why you're a great candidate for this.
Little known fact before I get into how great I am. The first time that I met Murray was the day that I was waiting for bar results, and we were at lunch.
Was it with Jocker?
No, it was with Stevenson. John Stevenson.
Okay.
The three of us just sitting there. And I mean, I have no real recollection. They're talking, and I'm just sitting there like, I'm going to get fired if I fail because I was a pre-commit. It was just, but, Murray was very gentle.
Yeah, there we were. We were three prosecutors sitting around having lunch together. I recall that because we went to celebrate after that.
We did,
and as you must when you pass the bar. And I was thinking about that today. I know plenty of people that I knew before I took the bar, before they passed the bar. I knew plenty after. You're the only person I ever met the day they passed the bar. So I feel like I have a Wookiee life debt, or you have one for me. I'm not.
One or the other.
Yeah.
But no. So just for those, I think, few people that are watching this that don't know who I am. I have been at the office for 13 years. I was an intern there for 2 years, a pre-commit, and then was there until 2010, left, and then came back with Kim as a division chief over vehicular crimes and over 7 of our felony trial courts. So the last 6.5 years I was there, I was in charge of making over 300 fatal scenes. I was the sole decision maker on charging for every fatality in Harris County on the roads. And I was also in charge of 7 district courts, so I supervised well over 100 prosecutors during that time, making recommendations on the murders in those 7 courts. And really just being there as a sounding board and a cheerleader for the incredible amount of prosecutors that came through those courts during that time.
And you actually do have the benefit of having served in two different administrations and two different eras, really, because you first started towards the end of my stint there. You were licensed in 2007? And so I had about a year and a half to go on the clock at that point. But that would have started under Rosenthal, and then not very long into it, we had Ken Magidson take over.
Right. Well, actually, I've been technically under 5 DAs because you and I had Rosenthal, we had Burt Graham, we had Magidson. Yep. I had Likas.
I was not invited. I was not invited to attend that party. But there's so much. Sometimes I marvel at how much things have changed since the time I was at the district attorney's office to where it is today. And I think that anybody that looks at where we are right now would agree that just our attitudes towards criminal justice in general have drastically shifted over the past 20 years.
No question.
And as you're sitting here, where do you see the future of prosecution going, and what do you plan to do to address it?
Well, I think we've seen a sea change and a true shift, I think, for the better overall in the way that we prosecute and what we deem as appropriate to prosecute now. I think we've understood finally that the war on drugs has failed. If it was ever a winnable war, that ship sailed a long time ago. And so, over the last 20 years, we've given lip service and kind of patted ourselves on the back with reintegration court and the misdemeanor marijuana diversion program. But we've got to, for the first time, get intentional about the way we handle those cases. We've got to really segregate them from the rest of the criminal justice system. And I think something that I'm excited about really investigating and probably implementing is the community courts model, if only for the narcotics to begin with, where you have satellite locations that aren't staffed completely with just cops and prosecutors and judges, but are staffed with addiction specialists, that are staffed with mental health specialists, and with community leaders of that community. Because the groups and the community that is Sunnyside or that is Pleasantville, their needs and those people's needs are different than it is in Kingwood or South Houston or Pasadena. And so if we can get enough of those community courts and make it a robust diversion program, then we can alleviate a lot of the overcrowding at the Joint Processing Center. I'm not even talking about the Harris County Jail, just simply the way that we intake prisoners. If we can drop them off over there, then I think we can do other better things with them. And look, we've all been in this game long enough. We're not going to save them all. We all know we're not going to save them all. But if we can put 15, 20% of those people on a different path, on a chance for success, partnering with the unions, partnering with other stakeholders to actually get them on a path to being productive again. Man, the amount of bandwidth we've opened up to really deal with the violent predators that we have to deal with, and not, again, just give lip service to being evidence-based and actually prosecuting them and removing them. It's a twofold win, right? Because we've given ourselves bandwidth to do it, and we've created so many less of the next generation that have nothing left but to post up outside the Galleria and follow people home. So I think that is the sea change that you've seen nationally, and I'm excited to actually bring it to Harris County.
Do you see this being operated out of a JP outpost type of
something
situation?
in that vein, right? I mean, we already have them there, and right now, for the most part, they're either evictions or, tax collecting on traffic tickets.
Right.
We might as well utilize them for something that's beneficial. And so we've got 16 of them already sitting out there. Why not incorporate them?
And one of the things that's kind of a side effect that you bring up on this is that when we talk about these outlying communities, Harris County is huge. And if you think about how many people are charged with low-level drug offenses that have to make that trek
Right.
all the way to downtown, which is a disaster for even those of us who go in with reserved parking every day. You know, you're basically asking them to compete in the Amazing Race just to stay out of jail.
Correct.
Yeah.
And that really is kind of a war. You know, luckily one of the things that has shifted over the past 10 years is we don't see as many judges that revoke you for being a few minutes late.
Right.
And hopefully that'll continue, you know.
But, you know, I think it's incumbent on us, especially now that we have the judiciary we have, which is more geared toward being down the middle and having some compassion for defendants. If we're not attacking them from the DA's side, if we're actually working collaboratively to do the right thing, which, you know, is our oath, and we work with HCCLA and the defense bar and the judges, why are we still, in such an antiquated way, requiring defendants to show up every month for status checks? I get for us, and because I understand human nature, it probably is important to have cases on the docket every 4 weeks or 6, just to make sure people are doing their job. But to require the defendants to show up there, and that's not saying that we're not requiring them to come down and take, you know, urine tests or anything else. The other 2 weeks that they're not there, it's an old, antiquated system. And we're costing people jobs. We're costing people, you know, that are hourly wage earners. We're costing them way too much money and making it punitive before they're ever convicted. And so I want to work collaboratively with all the stakeholders to reduce the amount of appearances that the defendants have to make. And I think we're there. I think we can get there pretty easily with our judiciary, with the defense bar. And if you want them to zoom in just to check in and say, hey, I'm, you know, not in Cancun, great. But I don't think we should require them to do the Amazing Race every 4 weeks.
And you know, I remember a very sobering moment when I was still a prosecutor. I had a PSI in front of Judge Cosper, who's one of my all-time favorite great judges to practice. When I got really hot and bothered, it was a fatality case, but it was kind of a negligence-based situation. I wanted pen time for it. It wasn't really a pen time case, and I was arguing for it. And Judge Cosper, who I normally got along with great, you know, was very frustrated with me, and she finally said, you know, Mr. Newman, in this business there are people that we are scared of and that we are mad at, and it would behoove you to learn the difference. And that, I think that we have kind of shifted towards the Cosper way of looking at things, but I think so much more can still be done.
I agree completely, and she had so many one-liners that were incredible. That had a lot of information in them.
Much like Yoda, 4'11", filled with wisdom, Judge Cosper.
But I think in that same vein, a negative shift in that attitude that we've seen is the relationship between the DA's office and the defense bar. I think that the DA's office, as it's currently constituted, has become very much of a bunker mentality of a us versus everyone else in that building. And that wasn't ever the way it was when we were there together, and even after you left to a certain extent. We were kind of bunkered inside the building, but I had as many friends, and to this day have as many friends on the defense bar as I do inside the DA's office. You can be adversarial and not be adversaries. Yeah. And that's where we have to get back to, I think, not blaming the judges on everything, because that trickles down. From the very top, it becomes a cop-out for young prosecutors if they see the judges getting blamed. That was never something that we were allowed to do.
No.
And so we've got to get back to having some accountability, understanding that it's not always going to go your way, and the person across the courtroom and the person in the front of the courtroom are not your enemies. We have to work together in a lot of ways. And so I think Cappy's line needs to be utilized for everybody. There are people we're scared of. There are defense attorneys I'm scared of, either for ethics or just because they're better than me. But you can't be mad at them and take it out on them.
So how do you rebuild that? Because for lack of a better term, you've got a fire here that needs to be put out, and rebuilding needs to be done?
And I have a lot of how questions because I
Yeah.
love a lot of what you're saying.
Yeah.
You know, one thing that I've noticed, and I know y'all don't come down below the 14th floor a lot, but the misdemeanor courts, there's actually now some judges who I have a great deal of respect for. I need to ask them why, who are now starting to re-require appearances on a regular basis of defendants. And I gotta believe, because I know them well enough to know that they've got a reason for this, and it's gotta be what they think is a good one. I haven't talked to them yet, but how do you get judges to start waiving appearances? How do you build a better, like Murray said, how do you build a better relationship with the defense bar? How do you create these satellite courts? And then what do you like dismantle reintegration court and spread that around those 16 JPs? I mean, I'm just curious.
I certainly think that that's something we've got to look at. Dismantling Rick and doing something different. Rick was a wonderful step in the right direction, and I think Judge Thomas does an incredible job with what he's got.
He's got one of the biggest dockets in that whole building,
Exactly,
right? It started off, it was all trace cases.
It was all trace cases.
Now they got third degrees.
You're up to anything under 4 grams, and so it's too big, right? I mean, you can't monitor them.
Right.
You can't do anything to truly rehabilitate them, because look, I grew up with an addict, right? You're going to have relapses. You're going to have issues that shouldn't land you in prison necessarily, but we need the resources to help keep them on the path. And so I don't think one judge can do it. I don't think one prosecutor, as much as Maritza has bought in, and I think she's an incredible
fantastic
prosecutor.
job. Everybody in that court.
Absolutely. I just think they're inundated. They're overwhelmed. And so what you've got to do is, instead of, going to challenge Commissioner's Court and saying we're being defunded, go to them with specific plans.
Sure.
Right? And say, look, here, I need funding for this, and here's why we think it's going to work. I need funding for more prosecutors, not to grow my empire, but to help facilitate X, Y, or Z.
Sure.
So I think that that's going to work. That's certainly going to be my plan on that. And the judges, we all know them, right? I mean, they are, for the most part, friends of mine, both on misdemeanor level and felony level. They're very smart. They care about their job. We're going to sit down, and maybe they have reasons that we don't know about, and maybe I pivot, right? But I'm going to have frank conversations with them. I'm not going to send them open letters. I'm not going to threaten to run people against them. We're going to figure it out collaboratively, because one thing I know about every one of them, the county and district court judges, they want this thing to be better. They have ideas. I have ideas. We can work together on the global sense to get those things going the right way. At the ACLU thing, I was talking about the way that I want to change probation and the conditions of probation, and I want to partner with the trade unions. They already have the apprenticeships built in, right? They have the infrastructure and the apparatus to monitor these people. And my opponent's jab at me was, well, you should run for judge because they control the conditions of probation. And I don't know if it's ignorance or incompetence or just the fact she likes to lie, but every prosecutor knows, every defense attorney knows, the prosecutor writes the conditions of probation in every plea bargain, right? And how many times have you seen a judge change those, right? It doesn't happen a lot. They'll go what the Teare says on top of what you recommend. So, of course, the DA has a huge input in that. But I am not going to be a unilateral decider on these kind of things. We're going to work with the judges to get a lot of these things done. We're going to work with Commissioner's Court. And I won't be able to implement everything I want to implement for a number of reasons, right? I mean, budgetary restrictions, the judiciary isn't going to go with me, and that's fine. We can't and shouldn't agree on everything. But they're going to hear my point of view, I'm going to hear theirs, and we're going to do it behind closed doors, and we're going to come out with a coherent plan going forward that everybody sees.
I had seen some comments by DA Ogg about your criticism of probation, and talk a little bit about what your plans are, what you would like to see probation terms look like.
So, I mean, when you think about probation now, right? I mean, when we were prosecuting back in the aughts, there was a ton of conditions on probation. None of those conditions have changed. They're still the same. We've just added on more, right? So, I mean, you're looking at like 14 I saw one time, different conditions on a probation of 2 years.
I've got 32.
Yeah, I mean,
Yeah.
but so I'm a 44-year-old father of 4 that coaches Little League. I don't think I could successfully complete a felony probation.
Amen.
Right?
Yeah.
So it is a setup. It is just a path to prison.
Well, and if you remember when we were younger, I mean, when we would go to baby prosecutor school, they actually touted it like that. They called probation the time before time.
That's
right. And they were
Seriously?
like,
Yeah.
they're like, who cares? Sign them up. They're going to mess it up in 6 months, and they'll
Exactly.
be in the pen. And there really was, and even when Rick Court came out, you know, when they first started at Star Court, before that, you know, I remember the reaction from a lot of DAs. I think this was actually a little bit before you, that we're like, Star Court, what type of hug a thug type of program is this, you know? And, you know, luckily we have shifted to that, but in my opinion, it seems like we should shift more, because the non-scary people, you should be rooting to succeed, not fail. So.
I mean, that's the whole point. We've got to get to the point, and I think it's the bail thing too, right? There's a differentiation. There is a real life differentiation. There are people that are broken that we can help, and there are scary people. And the scary people, at least for a period of time, need to be removed from society. The vast majority of the people in the Harris County Jail aren't scary people. They are just broken of some way. But to get back to your original question about what I want it to look like, I want to eradicate most of those conditions. They're conditions that have been around since before I started, right? Obviously, I think BIP, you know, has proven to be somewhat successful. I think that there are some good things around the violence, you know, of intimate partner violence. But for the vast majority of these, especially younger people, the fact that we're not saying, you know, all right, you have barely graduated high school or haven't graduated high school, you get 1 year. You go to either the Plumbers Union 68, you go to IBEW, the electrical workers, you go somewhere, get in their apprenticeship program and learn a trade. Period. I don't care if you subsequently wind up going to college and, you know, 4.0 and become a PhD in something. But for this year, you go under a journeyman and learn a trade. And if you do that, because they have everything already built up, right? They have the supervision, they do drug tests, they do all the things that we're asking them to do. And if in a year, they can earn money while they're doing it, right? If in a year, the journeyman who's teaching them comes back and says, this person is on their road to becoming whatever that is, why am I hanging on to a UUMB or a Berg building or anything else? Case is dumped, expunged, gone, right? Those are the kind of people that we are going to see the recidivism rate of be in the single digits, right?
Sure.
Versus if we put them on, you know, a 1 year deferred that they screw up in 6 months, they get finally convicted, maybe they never go to prison, they're done.
Right.
Like, they're done. They can't ever get a real job. They can't ever get an apartment. They're never going to do anything. And so eventually, we're going to see them
Back
in a
in again.
much more significant case.
Right.
And so, again, it's just like the dope. We're not going to save them all. But if we can really save a large number of those, this county won't look the same in 8 years.
Do you feel when you're sharing this message out on the campaign trail, you know, that a lot of people are trying to hit back and saying, oh, that's just a soft on crime approach to things? What's your response to that?
If we're talking about those kind of crimes, then sure, I want to do something different. I don't want to create the next generation of violent criminals. That in no way means they're not going to get held accountable. It in no way means they're not going to get processed and dealt with, right? But, you know, all these people, oh, you're not going to convict them and make them a thief for shoplifting. Does convicting them and giving 3 days credit for 2 do anything more to prevent them from doing that?
No, it just ruins their resume.
It just ends their career of being anything successful. So, yes, they're still going to get taken. We're still going to accept the charge. But it's the outcome that we're going to change. And so saying soft on crime just shows that you have never spent a day down in the courthouse and talk to rank and file cops, rank and file defense attorneys, rank and file prosecutors who don't want to do this anyway, right? So it's being smart, and that's what I explained to them. But in my mind, my real job as the elected is to empower the prosecutors that are there to make decisions. I mean, when we were coming up, the mantra at that office was, if you can justify your decision because you were prepared and you know the case, and you thought that you were following your oath, it's the right thing to do, that's it. You tell me, and then you go back and do your work. My job is to fade the heat on any decision, right? That's the elected's job. And if prosecutors believe that, if they truly believe in that, you're going to see the right outcome happen. You're going to see dismissals when they need to be dismissed immediately. You're going to see plea bargains that reflect what justice is, not wrecking the max and just letting somebody else try it in 3 years. You're going to see the right case go to trial and the right case dismissed. All of those things happen when prosecutors feel safe from above. And that, if I do nothing else, is going to change day one.
Well, one of the things that just always just kind of stunned me about the Ogg administration, and you and I have in common that we both supported it back in 2016.
100%.
And
Took a hell of a pay cut to come back.
and changed our minds ultimately. Sadly, after having enough things, shoved down our throats. But it stunned me, the level of micromanagement that she brought in. Like when you were having very senior supervisors looking at how people disposed of a state jail and going back and pulling those records. How on earth could any prosecutor feel like they had any type of level of discretion?
You can't. And I liken, we all know who we're talking about, but I liken that as the beginning of the end of any prosecutorial discretion in the office, very much like the front page of the Chronicle. Was it incompetent and with Riffy Nuez where Lycus
Donnelly.
Yeah. Where Lycus called them incompetent,
negligent and incompetent.
Front page of the Chronicle on a Batson challenge that had no business being granted, and also she had not even read the transcript when she called them that killed any prosecutorial discretion in 2009 or 10. The pulling of the records, the challenging of all of those things on cases that no one was talking about, that were just the right thing to do, effectively ended anyone doing the right thing in that office right now. So those two, I liken those two events to kind of the end of administration.
So how do you fix that?
You got to be present. You have to be down there. It's going to be something that with my very first speech to them, we're going to start to impart. We're going to bring back some of the old guard that's going to get that message down as deep and far as we can in the ranks. But it's got to be me. It's got to be me walking around the 5th floor, walking around the 4th floor, not to check if people are at their desk at 4:30, but walking and just sitting in felony 2's offices, sitting in misdemeanor 3's offices, just ask them how they're doing and letting them know that I care. I think it's going to involve me trying a case a year. I think it's going to involve me working a docket a month, just so I'm there, so they know that I care.
You'll try to come down and try cases or come up?
I will try a case a year minimum.
Okay.
Who wants to be at the DA's office and not try a case?
There are plenty.
Okay, I personally want nothing to do without being able to try a case. And I will try one a year, because I don't think that you can ask anyone to do something that you're not willing to do, right? And I think it's working dockets. Like, I just go sit in there and deal with a misdemeanor docket 1 month, a felony docket the next month, and go across the board so that you know what everybody's dealing with in every court, and just be present, right? I mean, we've had an absentee landlord there for 8 years. We've got felony 2s who've never shaken her hand. So that changes, and I think that starts to change that mentality. But the only way that you really change it is time and proof. I mean, something bad is going to have happened where it's a negative for the office, but the prosecutor can justify it. The only way this changes is me standing up and facing the music on behalf of somebody who's working with me. And I know it's coming. And I just don't think you can try to have this job without having thick enough skin to deal with it.
When I was there, and it's been a long time, obviously,
It's true.
but we used to have like regular training. Do they even do that anymore as far as like just training someone how to try a case?
I was going to get to that.
Or
just like what the rules of evidence are, or how to
Just
lay
how
a
to introduce a
foundation
picture.
of a video or a photo.
Yeah, and I mean,
Fairly and accurately. Does it fairly and accurately depict the scene at the time, or whatever?
I know.
Sorry.
I know.
And you know, and I mean, when we were in misdemeanor, I'm sure it was the same for you. You were going to trial every week, like every week, and it didn't really matter if you lost. You weren't going to get in trouble if you lost, and you just went in there and you learned how to do it. And it seems like so much of that is lost now.
100%.
In some of the cases that I've tried, or just dealing with the prosecutor, that you walk in and you point out something that should be very self-evident is a huge problem with their case, and them defiantly telling you it's going to be fine. Okay. I mean,
And all evidence to the contrary, because we're losing 40% of our felonies.
Sure.
So it ain't going to be fine.
Right.
Right. And I think, to answer your question, the training is not good, right? They vacillated through the last 8 years of just a bevy of mandatory trainings, that no one attends, to we just don't train. And so you've got to get the happy median. And I don't know if spring training isn't on the table, right, to come back.
Okay.
That was an old actually Johnny Holmes deal, but there's got to be some effort and some cohesive plan to do it. I think a lot of it is me going to some of the really people that we've respected our whole career, and Ted Wilson teaching search and seizure and Fourth Amendment stuff. People are going to go to that, right? But what we also have to do is the basics. I mean, we've got to teach. I've got felony 3s that can't introduce a video.
Yeah, I
Right?
talked to Austin Hobbs.
Yeah.
Austin Hobbs will tell you about an experience yesterday.
And so I think one of the ways we go about doing that and getting them on the job training is we don't have the no test, no accidents anymore that we all
Right.
cut our teeth on. I mean, you drive 5 of those a week, it just didn't matter.
right.
We've got to get court trials. We've got to change the way we promote. We've got to trust the judges, both in county courts and district courts. And we got to start trying some of these to the courts, because at the very least, that's going to teach them advocacy skills. It's going to teach them the just nuts and bolts of how to introduce evidence. So I think that's one of the paths. I think you get some experience in there, and you just let them go try some cases.
Yeah.
Well, a lot of people, when we start talking about how important morale is within an office, a lot of people say, who cares? I mean, I don't sit at home and wonder if the people at the Pentagon are happy. People don't. So when we talk about the importance of whether or not people are happy at the DA's office, what they don't realize is that people that aren't happy don't stay.
Correct.
And one of the things that has just been absolutely stunning to me, having now been on the defense side of thing almost twice as long as I was a prosecutor. I know I haven't aged a day.
No, you look
but that's what happens.
Your
when you
hair
turn
got
bald.
shorter.
When you turn bald at 15, you don't age a day. But the thing is that it used to be like becoming a felony district court chief was like being a made man in the mafia. You
Yeah.
had paid some serious dues. You'd been there at least 7 years, and now you've got people that are coming up and they're chief in 2.
Right.
And how on earth, if the chief is going to be a leader of a court, they're supposed to teach the people below them? Because I mean, we used to look at them like the Jedi Council. When you
course,
started
yeah.
at the DA's office, if someone was a district court chief, they were the ones that knew everything.
Right.
And now you may have taken the bar next to the district court
Right.
chief.
I mean, what's crazy is when I started, he and Petrov were like the guys I looked at as that knew everything. I've realized.
Petrov also is not aged because he's perpetually 13.
He's actually
He looks
going
13,
backwards,
but
hi, Petey.
he grew a beard the other day. It was really off.
But you're exactly right. Like I was on promotion committee for the last 6.5 years before I left. We made a district court chief before I left that had 5 felony trials.
Wow.
Think about that. Like, and oh, by the way, had only heard a 1-word verdict twice. So how can you ever expect the felony 3 or even the 2 to go to that person and say, hey, I've got a DNA question?
Well, or they do,
And
they get
the wrong answer.
information.
I know. Believe me,
And then,
it's going to be a heavy lift.
one thing I talked to Austin about today, I just got to say this, is with the Court of Appeals continuously finding like evidence issues are harmless error and things like that, judges overruling and allowing evidence in, and I don't know that there's a lot of incentive for them to learn and do things differently if judges don't continue to hold their feet to the fire. I'm just going to say that as a side note on other things, but
Well, I mean, look, we're not getting a lot of appeals out of Harris County because we ain't winning a lot of cases. So I think that we're making bad case law because we're not trying the case right, even when we do win it.
right.
It's got to be a comprehensive rebuild. We've got to bring back some real talent and experience that we lost. We've got to empower and make the people that are there, because we've got a lot of talent there. I mean, we've got a lot of young, good, principled talent that feels just adrift. So we've got to bring them in. We've got to make them love and feel this culture that they're cared about. And it's not, this is the Titanic. Like, we're not turning it immediately, but we've got to start the steering. And so I don't think you're going to see radical change in the caliber of prosecution right away. But I think within a year, you're going to be pleasantly surprised at both the temperament and the competence of the prosecutors in the courts.
One of the things that I've seen, some of the AUG fans criticize you for is like, oh, of course the defense bar loves this guy, but that people don't realize that the defense bar benefits from good and competent prosecutors.
Absolutely.
100%.
Hugely, because when you are sitting there trying to explain why to a prosecutor who doesn't know what they're doing, why their case will never hold up in court, you can end a case like that for someone who's going to have to be dealing with it all the way up to trial time.
Right.
And there is just this absolute phenomenon that has occurred under the AUG administration of that if there is a victim case, that you are not going to get your dismissal until trial day.
Yeah.
And it's horrible.
And what she doesn't understand, and neither does Mitchum or Vivian or any of the rest of them that are up there, and I think it's because they don't talk to victims. They don't deal with victims. The victims go through as much angst and pain from the first time you realize the case can't be made to that trial as the defendant does.
Right.
In preparation, in worrying about it and everything, only to be devastated when you know the case can't ever be tried or you know you're never going to win it. And so all they do is stretch out that anguish and pain for 2 more years too, because they don't allow their prosecutors to have the discretion they should have when a case is fatally flawed. So I've spent the vast majority of my career working with families and victims of violent crimes. I know the pain that they deal with and go through. and I want to see justice for them. But if we ain't got it, we ain't got it.
Right.
And the way that you can make it better for those families and those victims is being upfront and straight up with them when you find out. That doesn't happen.
Not to mention culling those cases.
Now I got
lets
time.
lets you get to the cases that you can make.
Right.
Exactly. And work them up.
And not leave somebody else, having, by the time that it gets to trial, that they've dealt with 5 to 10 different prosecutors.
Exactly.
I tried a case to trial about a year ago, and when the outcome came out, and a prosecutor mentioned me, I was on that case earlier. I was like, were you? I mean, I forgot. I've been here the whole time, but it seems like I've seen half the office on this case. And how does it serve a victim's family or the victim themselves if every 5 minutes they're getting a new prosecutor, which goes hand in hand with this morale and turnover?
That's it.
It does matter if it's a happy workplace.
It does, because, I mean, when we were there the first time, chiefs were typically 5 years in a court at minimum, right? A 2 was there for 18 months to 2 years at minimum, sometimes 3 years in the same court, meaning you handled a lot of cases from PIA to trial, right? And by the time you get to felony 2, you should be handling cases, a lot of them, where the victims just know you.
Right.
Right? The victims just know you.
Suddenly we have 8 comments.
I'm monitoring them. I'm just trying to wait.
Okay,
Just
you're
trying to
waiting
get
a
in.
moment.
We got a good spot right now.
Yeah, we do have a
We've
good
got
spot.
Three,
Yeah.
three questions
Let's
coming
go.
about the death penalty. You're talking about victims and violent crimes before your opponent you're challenging took office. I think she kind of came out and said she was going to stop seeking death on cases.
Yeah.
What can you tell us about that
So, look, I think
in your position?
historically, the death penalty has been so overutilized, especially in Harris County. I think that it has been so disproportionately used against black and brown people and poor people that it's a travesty. I really do. All of that to be said, I specifically know that there are individuals that are too dangerous to be anywhere other than death row and being put to death. Look, if the legislature would have a category for life without parole, solitary confinement, I can tell you right now I wouldn't seek death. But when you get LWOP now, they're going into Gym Pop.
Gym Pop.
And there are individuals that I have handled that will kill again, that will hurt other people, even in that population. And so when your only 2 options are life without parole in general population or the death penalty, I think it is a very small percentage of people, but I'm not going to, unlike others, I'm not going to promise things before I win that I'm going to go back on. I'm going to do everything that I tell you I'm going to do, and quite frankly, nothing I'm not. And so I'm not going to commit to not seeking the death penalty. I would love a world where I don't have to, but I think part of my responsibility is to protect the community as a whole. And there are people that are quite frankly too dangerous even for general population in prison.
I'm going to hold off on some of my thoughts on that.
You took a deep breath there.
Yeah. But so how do you, I don't want to ignore the other comments, but how do you make that determination of if somebody would be better off just in solitary, or we should just, wipe them off existence?
I mean, how does the elected or any DA make any determination about someone? We don't have crystal balls.
Sure.
We're not going to be
That's
100% right on any of them.
But when you're dealing with life or death,
I think you have to look at all the factors. I think it's incumbent on the elected before they make the decision to seek death, because we're not, not by myself doing it. You have to be able to have good defense attorneys that are going to put together a real mitigation case for you. I think that as the DA, you have to also go try to get as much mitigation as possible. I think the default should always be not seeking death. And then you have to move over here. You've got to look at behavior inside custody, awaiting trial. You've got to look, quite frankly, at criminal history and what type of criminal history you're talking about. I think you do have to look at the crime that is committed, but I think we have gotten way too much historically on that crime.
Sure.
Right? And that's, we have to kill this person because of that crime.
thing.
Like, that's not what the special issues ask.
Right.
Right? And so we've got to always be looking toward, as you do in every trial, what the verdict form looks like and what the questions are. And so I think that's why you've got to look at the mental health, you've got to look at the mitigation, you've got to look at everything else before you make the determination just to seek death. And I think, like a lot of things, that decision can be changed, right? I mean, as you go forward in a case, in any case, you learn more. So an initial decision doesn't always mean that we're going to go all the way through it. In some cases, it just means both sides get more resources to dig in.
So shifting gears a little bit, this is the first election cycle that we've had for the top law enforcement in Harris County or in the state since that new legislation went into effect, where the governor, how does it work? The governor can
where you can have someone removed if
Yeah,
you feel
right.
that
You
they're
just
not.
remove prosecutorial discretion.
And
Awesome.
it took about,
So-
3 days before someone started abusing that?
Yeah.
I think
Yeah.
like you had to, it was Kamal County where the
Yeah.
district clerk tried to remove the DA on day 3. I mean, how do you
navigate
around
that? How do
Yeah.
you campaign? How do you I mean, I don't think the campaign, what you say during a campaign could trigger that law.
I'm very cognizant of it when I talk,
Right.
even now. But the blanket is you can't refuse to prosecute any kind of case.
Sure.
Right? And so, okay, I blanketly, I won't say that, any kind of case is prosecutable. They can't define what a prosecution is, what an investigation is.
Okay, that's fair.
And so, I think the biggest one for me, there are a number of them, but the biggest one is the new abortion law.
I was going to ask you about
I mean,
that.
I've got a wife.
Because you've come out pretty strongly
I think
on a certain class of cases you won't prosecute.
I think it's incumbent on us, right? I think that by us not having the courage or the ability to tell doctors and women that they will never ever face prosecution for seeking reproductive health care, we're killing women. Sure. I think we are killing women. There are women that are either not going to seek life-saving reproductive health care and they're going to die, or there are women that are going to take that health care back into the shadows like it's 1950 again, and they're going to die in back alleys. Mm-hmm. So not saying that is going to kill women. And I can't say that because I want to keep this job. So what we have to do is be very upfront with all of the medical personnel, with all the women, and they have to understand what my hierarchy and priorities are. I've got limited resources, and so the resources that I'm going to devote to, let's say, my capital murders, my murders, the death cases, the aggravated robberies, the sex assaults, child abuse, all of this, we are going to devote the vast majority of our resources to that. And as we go down, there's going to be less bandwidth, less resources to prosecute different kind of cases. And so in my hierarchy, those are my top. And then somewhere way down here, and for those that you can't see, my hand is literally
Very low.
on the ground.
It's very low.
Is going to be expired registration and, speeding. And then,
marijuana?
35 feet below that is going to be investigating doctors and women.
Well, and this kind of ties into a kind of a two-part question that I have, because someone has asked about how you fix the intake system. But when we talk about the women's reproductive rights, things like that, there is a defense available called necessity.
Correct.
And when we talk about that, how could you utilize necessity into the intake system? And would you encourage prosecutors in intake to look at that before making a decision to file charges?
Well, number one,
You just lead the guest to the answer? Like,
Maybe.
yes.
it's what he's been doing
Yes.
forever. But here's the deal.
Wookiee like
right?
that.
Number
Gotcha.
one, intake is never going to accept one of those charges, right? I mean, that's the kind of case, if one of those is ever accepted, it is going to be after a specific division investigates it and we present it to a grand jury. So intake's never even gonna sniff.
For those who don't know, you're talking about the phone's not going to ring, and they're like, oh yeah, we'll take that, charge that doctor right now, hook him up.
Charge him with abortion.
But I mean, it's if we can't laugh, we'd cry. But
We're interesting people.
The overall fixing of intake is one that starts January 1st, 2025. We're going back, and you know, I think we're gonna see some prosecutors not want to continue to work there because they haven't grown up with that, and it's a real world. It just becomes part of your life when you're required to do 5 shifts, and then people just sign up for it. And so you're gonna see some people that didn't grow up with it that are gonna be required to do their shifts and not want to do it. But that's going to be okay, because I think in pretty short order, we're going to get the office back to the way it should be. And intake, as you well know, is a self-policing entity when you have it working right. Right? Because down there right now, there's no accountability.
No trial lawyers in there.
There's no trial lawyers, but even if there were trial lawyers that were taking a break, there's no accountability.
Right.
Because they can take a charge and they never have to see it again. They don't even know the prosecutor that's handling it.
Right.
When we were there, if you took a bad charge, it never landed on your desk. It was always 2 doors down, one of your friends, and that next morning it was marched up and down the hall talking about how dumb you were.
Yeah.
It was self-policing.
Mm-hmm. Sure. Somebody throw it on your desk. You try this.
You try this.
Yeah.
Right? And then they take it to your chief, and then your chief would jump. Like, that kind of real world thing fixes itself day one because there's accountability. Right? There's accountability on those kind of cases.
I want to get to a couple of other of these questions because there's some good ones. There was a newspaper article recently about the findings of no probable cause that were happening. What would be your policy regarding cases where a judge finds no probable cause on a case that was accepted at DA intake?
Misdemeanor you're talking about?
Any case.
Okay.
Any of them. Look, unless there is new evidence that comes after the finding of no probable cause, we're not second guessing, we're not attacking the judges. The case is gone, right? I mean, the fact that they just out of spite present so many cases that have a no PC finding to grand juries, misdemeanors, is just, it blows my mind. You can't do that. But look,
especially when they end up back in front of the same judge who's going to determine probable cause as part of a suppression issue right after the jury's sworn in and jeopardy's attached.
Trust me when I tell you, there's no benefit to doing it. And that's why my baseline is no PCs found, the case is over, unless new evidence comes to light.
Right.
We're going to treat it just like we do with a grand jury, and that's going to be it. But I promise you're going to see less no PC findings when we fix intake.
Right. That would make sense.
You're just going to. We're either going to strengthen the case, or we're going to know that case is not going to get made, and therefore we won't take it.
So you're not going to run any ADAs against judges out of your office?
No. That is, we are not going to encourage anything like that. The encouragement of judges or of prosecutors to run against judges was it was just ridiculous. I mean,
Kim Ogg's mailer told that makes her a good Democrat.
Yeah. Well, David Mitchum, who he makes me sad. But
same.
Yeah.
He lost me when he lied specifically about me to the media about the Abbasi case, but that's neither here nor there. Right. But he set me down on 3 different occasions and asked me to run against 2 different district court judges. Right. And he was in charge of recruiting in that office to run against judges. It's just not it's not the way to do it. It's just not the way to do it. And so we're not going to do it that way.
Right. We have.
Is it an open question? Like, would you like to run for a bench, or Sean, I want you to run for this bench?
Oh yeah, no, it was, I'd like you to run against this person. We think you'd be great.
We're looking at the other comments on here. We're not
I am, and this has gone by fast. We only have 2 minutes. My friend Janie Jo Maselli Wood has said, "What do you think of the DA's insisting on a trial when a defendant wants to plead
Oh
guilty?"
yeah.
That goes back to trusting the judges, right? It goes to, you don't want to take my plea bargain offer. We're not gonna affect the state's. The fact that the state has a right to a jury trial blows my mind.
Yeah.
But we're waiving that day one. So you want to plead guilty to the judge and go PSI or just have them assess punishment? Perfect. I've got thousands more behind you.
Yeah.
Right? Like it boggles my mind that we don't trust our elected officials. And that goes to running against them and everything else. We're going to work collaborative.
We got 1 minute left. What do you tell the defense bar what it's going to be like working with the Teare administration?
Phones are going to get answered. Emails are going to get returned. We're going to be competent. We're going to be honest and trustworthy. And I hope that we become the office where defense attorneys can feel comfortable sharing the faults and the problems with cases, knowing that the prosecutor is going to do the right thing, because I think everyone benefits when those kind of things happen. And most importantly, my upper administration is going to be available. We're going to have conversations. We ain't going to agree all the time, but we're going to be very upfront and able to be talked to.
All right, we got 30 seconds left. Sean Teare, my friend, candidate for district attorney, thank you very much for coming on and giving us some of your very limited time that you have these days. We appreciate it. On behalf of Harris County Criminal Lawyers Association, thank you, Justin Harris, for coming back. It's good to see you in person.
Yeah.
And thank you all for tuning in, and we will see you next week. Whatever you do, remember to go vote.